Hello everyone, and welcome back to today's video. We've got three foolish defendants appearing in court, each providing moments that are hard not to laugh at. All of them made the mistake of blurting out what should have been kept to themselves, and now they're facing serious consequences, including losing their freedom. We'll kick things off in Indiana, where one defendant was arrested for breaking the terms of his bond after landing himself in even more trouble with a new charge. Let's get started.
Case 01D01 2601 F65, State of Indiana versus Michael Mock. Mr. Mock is present in the courtroom via video teleconference from the Adams County Detention Center. His attorney, Mr. Cowan, is sitting right here in front of me. Mr. Chad Thurston is present in the courtroom for the state. He appears via WebEx. This hearing is being broadcast on the Supreme Court's website, and recording of it is prohibited. We're here after a notice to the court 1.1, a notice of a violation of pretrial services. It alleges that there was a pretrial release condition number 9 that was violated that says you shall not commit, be arrested, or charged with a criminal offense during the period of pretrial release. The court takes judicial notice of case 90D01 2602 CM38 over there in Wells County, which is a pending matter that was filed in Wells County last week. And based on that, the court notes the violation of pretrial service, issued a warrant for Mr. Mock's arrest, and that's why we're here today. We have let's see here. Looks like we have a attorney conference that's scheduled for February 17th. The omnibus date in this case is March 30th. Mr. Cowan is already representing Mr. Mock. Mr. Cowan, is there anything that you'd like to put on the record here today?
Judge, my client would ask that he be released back onto pretrial services. He doesn't believe that the charges in Wells County are valid. Okay. That they happened while he was arrested on February 3rd. He believes that all stemmed from a matter that happened before February 3rd.
Okay.
He'd like to be released back onto pretrial services. And if not, then Judge, we just need to set this matter. Either way, we need to set this matter for another pretrial conference because there's some depositions he wants me to take, and then we can hopefully get a better assessment on this case.
That makes sense. The attorney conference is already on February 17th. Do you want an additional pretrial conference after that?
The February 17th. Well, if we have an attorney conference, Judge, that'd be great.
I'm sorry, an additional attorney conference?
Yeah, I'm sorry, a pretrial conference in the court.
Okay, all right, yep, we'll do that. And then with regards to the request to be released, the court notes the probable cause. I note it is probable cause, and Mr. Mock definitely has a right to defend himself against the charges in Wells County, obviously. But with regards to that issue, because it's pending, because that was a condition of pretrial release, the court did not meet that request.
That's 3 conditions. That's 3 conditions in one. I can't help it. I was arrested on a charge stemming from July 2nd of last year, and it was in my own driveway. And there's common massacre.
I'm not going to let you do Mr. Mock as talk over me. I'm sorry. I didn't already instruct you. I didn't explain to you before that you can't have bifurcated representation. You can't speak and be represented by counsel at the same time. And so Mr. Cowan is representing you, and he's made very clear that you're contesting the issues there in Wells County and that you have defenses to them. And obviously that I'm not the Wells County judge, and so I'll let you take those up with the Wells County judge. But with regards to this pretrial release, that condition has been violated because of those new charges, and so we held without bond for the time.
That's against my constitutional rights. That's against my constitutional rights. I paid $500,000. What?
That's all we have this hearing. This hearing is concluded.
All right, you're a dick-sucking bitch, ho. Hey, John, I wrote Chad behind.
Officers, please hold him right there. Please hold him right there. We're not done yet. So far, Mr. Mock has referred to the court as a hoe and something else. You're going to be held in contempt of court. I'm going to hold you in. I find that you are in contempt, and you'll be held at the Adams County Detention Center for the next 30 actual days. Okay, keep it up, Mr. Mock, and you'll be held in contempt even longer. All right? 30 actual days is your sentence. This hearing is concluded.
He exploded in court, shouting a crude insult at the judge. The judge immediately stopped the hearing, pointed out his repeated vulgar remarks, and found him in direct contempt of court. As a result, he was sentenced to 30 actual days in the Adams County Detention Center, with a warning that any further outbursts would add more time. Ironically, he may have had a defense to the bond violation, arguing the new charge happened before his bond conditions were set. But by losing control in court, he committed a new offense, direct contempt, making his situation much worse. Next, we head to Colorado.
Paul LaBouche, 26 CR 9, 25 M 529, 25 CR 216. Okay, the defendant appears in custody. And this was a conflict, right?
Yes.
Okay. So, Mr. LaBouche, a couple things. Let me click over to your cases. Okay, so first off, I'll ask you, did you see and understand the video advisement of your rights before today's
Yes.
hearing?
Yes.
Okay. And in your cases, you have one new case. That would be 26 CR 9. All those rights that you were advised of in that video apply to this case. Do you understand that?
Yes.
The charges in that case include felony menacing as a class 5 felony. As a class 5 felony, that's potentially punishable by 1 to 3 years in prison and/or $1,000 to $100,000 fine. If there's extraordinary circumstances, it could be as low as 6 months or as much as 6 years in prison. It would also be followed by a 2-year period of mandatory parole. Count 2 is a charge of protection order violation as a class 1 misdemeanor. That is potentially punishable by up to 364 days in jail and/or up to $1,000 fine. So on your new case, do you understand?
Yeah, but I don't know when this case is even, who's it against? Who's the
The case is against you.
who's the victim of the fucking case?
That's definitely not something you want to say straight to a judge. At that point, the judge had clearly heard enough and shut it down, calling for the next case. And just like that, the hearing was over. They attempted to bring him back the following day to continue the proceedings, but he chose not to return to court to deal with the fallout from his behavior.
Okay, you know what, Mr. LaBouche? I'm
What?
sure you're inconvenienced, and I'm happy to answer some questions, but I am going to instruct you not to curse during this hearing. I'll treat you with respect. You need to treat the courts and those who are present with respect as well. So,
Indeed.
Mr. Fowler, the question was who it involves. Is that the name protected party that you're going to be seeking?
It is, Judge. That name protected party is very concerned about having their address out, and as asked insofar as we're able,
Okay.
to keep that information private.
So, Mr. LaBouche, the person who's alleged to be the named victim is a River Williams.
River Williams.
That's the name that I've been given.
I don't know this person at all.
Okay.
At all.
Well, that's what you're charged with right now. That's the person that's going to be the name protected party. That's what I can tell you at this time. You will have a right to discovery, so you can, if you're represented by counsel, they can get your discovery, which would be the reports and other evidence against you. You can also get it by, I think, simply submitting a written request, and the DA's office will get that for you. And that will have all the facts that they are aware of. So that's the first case, 26 CR 9. Additionally, in your other two cases, they have been filed as probation complaints. Go ahead and grab those. Your rights on a probation complaint are slightly different than your rights when you were originally arrested on the charge. In a probation complaint, you have a right to a hearing before a judge. You do not have a right to a jury trial. You would have the right to be represented by an attorney, and if you cannot afford an attorney, you can apply for representation by the public defender. If you're in custody, you would automatically qualify. In this case, Ms. Drinkwater, who's with the public defender's office, indicated they have a conflict. That's why they're not here today representing you. We also currently do not have any alternate defense counsel joining this hearing. Again, as it relates to a probation complaint, you are presumed to be innocent of the allegation until proven guilty by a preponderance of the evidence. That's another difference. The allegation does not have to be proved beyond a reasonable doubt, so it's a lower standard of proof. At that hearing, you'd have the right to testify, to call your own witnesses, to present your own evidence and defenses, to cross-examine and confront witnesses against you, and to appeal any decision you believe the court made an error. So those are the modified rights you have in 25M 529 and, sorry, 25 CR 216. I will tell you what's being alleged in those cases as well. They allege that you violated the following standard terms of probation.
I haven't even met with my probation officer yet.
Okay.
I meet with her on the 9th.
Mr. LaBush, just listen
I can't
to me.
even fucking talk or what? Fuck you. Fuck you. I'm done here, bitch. Later. Motherfucker.
I'll keep you updated the next time he shows up in court. We'll see whether he decides to behave like an adult or keeps throwing tantrums. Now, let's move on to the next hearing. A road rage plea deal that completely...
For the record, Mr. LaBush has just walked out of the video advisement, also cursed. Is there still a deputy in? Well, I'll make a record here. He's not presently in front of us. The behavior that was just presented to the court, both cursing after he was previously given a warning not to curse, and then specifically, basically telling the court to fuck itself, and calling the court a bitch because he was dissatisfied with the court's advisement, is contemptuous behavior that does not require a prior warning. I think I'm going to do that. Who do we have covering advisements tomorrow?
It's me.
Well, no, I mean Judge Weiss.
Oh, Gardner, I believe. Sandra Gardner.
Okay.
Yes, Gardner.
Here's what I'm going to, this might make sense, Mr. Fowler, since I think I'm going to actually issue an order in this case and have him brought over tomorrow, close in time to the advisements. Oh, we have deputies back.
Sorry, Your Honor, did you need something?
So I was just making a little bit of record. So I think this is what how I'm inclined to handle this. I think he does need to be brought over for a contempt. My inclination is to set this over till tomorrow, and maybe set it after the other advisements. So, what would work for the jail?
Whenever after advisements tomorrow, Your Honor. I can make any time work.
So here's what I'm going to do. Mr. Fowler, if you want to make that, I'll make an order. I want to have this brought over tomorrow at 2:30 for an advisement on contempt, and that will conclude the hearing.
That wraps up the defense attorney formally acknowledging his client's guilt and presenting arguments for a lighter sentence based on mitigating factors. Up next, the prosecutor addresses the court and reads the victim's impact statement, with the victim attending remotely through the online court portal.
Can you give me an update on his availability?
Yes, Your Honor, we had him shackled. He walked out of the cell, decided he didn't want to go. He said, fuck this, you guys can drag me. I'm not going.
Okay.
This is the moment where everything starts to unravel for the defendant. It's his chance to take responsibility, show some remorse, and ask the court for leniency or to shift the blame onto the victims and insist none of it was really his fault. Take a guess which route he decides to go.
Mr. Probick? Let's see. Mr. Probeck, 25 CR 1231, he's present. Good afternoon, Mr. Bibick.
Mr. Bibick, yes, thank you.
Thank
Good morning,
you.
Art. Good afternoon.
Yes, afternoon.
Good afternoon.
Yeah. All right, Mr. Probeck, a few questions for you. Make sure you understand the nature of this agreement, okay?
Okay.
You signed the paperwork, as did your attorney, and then there was a form you had to fill out, which you did. Before you did all that, Mr. Bibick, did he advise you on everything and answer questions to your satisfaction?
Yes, he did.
And are you satisfied with his representation?
Yes, I am.
All right, you're pleading guilty, it looks like.
Yes.
Let's see. Okay. Okay. So, pleading guilty to 2 counts, conspiracy to commit menacing, class 6 felony, and reckless driving. Is that correct?
Yeah.
All right. For the menacing, the class 6 felony, the penalties, the worst case scenario you could face are between 1 and 1.5 years in prison, followed by a year of parole. It could be a $100,000 maximum fine. Do you understand those penalties?
Yes.
All right. And then for the reckless driving, oh, good. I'm glad they. So it's apparently 10 days to 90 days in jail. And there could be a fine between $150 to $300. Do you understand the penalties there? Yes. Okay. Has anyone, Mr. Probeck, made any promises to you that are not contained in the paperwork here for you to do what you're doing?
No.
Are you entering into the agreement of your own free will?
Yes.
You take any medications or anything else that may affect your ability to understand what's going on right now?
No.
By pleading guilty, you are waiving your rights to go to trial. You sign paperwork indicating you understand those rights. Is that accurate?
Yes.
All right. And what about factual basis, Mr. Bibick?
Judge, we waive.
All right, waive. Let me ask you, did you go through the culpable mental state for you cover that with your client for the felony?
I did.
All right. Agreed. No. Gosh. Oh, it's with intent, right?
Yes, sir.
Okay. All right. Given the statements then by Mr. Probeck, Mr. Bibick, the court accepts the guilty pleas as knowing, intelligent, and voluntary. Stipulated. The terms are stipulated.
Yes, sir.
Okay. Well, happy to hear any comments regarding sentencing.
Thank you.
Yeah.
Shall I start?
Yeah.
Judge, this is a situation where Mr. Probeck was driving. The victim here and her husband were on their bicycles. They were approaching a roundabout, and there was a little disagreement about maybe who should be where as they went through the roundabout. And some words were exchanged between Mr. Probeck and the husband, Mr. Qualls. They were barking at each other, I guess we could say. And as Mr. Probeck exited the roundabout, he turned to his right to sort of continue that conversation. And unfortunately, his hands followed to the right. The car moved to the right, and it knocked Mrs. Qualls to the ground. From the discovery, it looked like she had maybe a fracture to her thumb. Mr. Probeck was insured at the time. Claims were made. He gave all the policy information. He did receive a letter from an attorney's office. I don't know if there's going to be further litigation on that. Perhaps there would be, but at least they've exchanged that information.
Honestly, paid the full amount. So.
He was, for some reason, charged with leaving the scene, but the video demonstrates that right after this happened, he pulled into the first available parking space, which was about 3 or 4 parking spaces up, and immediately returned to the scene and waited for the police to come. Mr. Probeck is generally a pleasant person, but in reviewing why he may have reacted as he did at the time, he's on certain medications, including duloxetine, and a known side effect of duloxetine withdrawal can be anger and irritability issues. I did some online research. I provided the district attorney with maybe 10 articles that are similar, that duloxetine withdrawal can cause anger issues. One of those articles was how duloxetine ruined my life, and people having to go through serious rehab to deal with those issues when trying to get off of this medication.
Probably have to wean off of it, something like that.
You have to wean off of it, and very, very slowly They talk about opening the capsule and removing maybe 3 of the beads to start with, and then working down from that.
Okay.
So it is a known issue. He stopped trying to wean off with his doctor. He's just maintaining his dosage, and he's managing it that way.
Okay.
Will he ever be off that? I don't know. But, I'm leery personally about any of these drugs. Well, we certainly tout the benefits and downplay the side effects.
Sure.
But at any rate, he's addressing it in that fashion. He's very concerned about what happened. He's happy that she was not injured more seriously. But we think under the circumstances here and the charges, he was willing to enter into a felony plea, essentially. We think this is an appropriate plea, and we'd ask the court to accept it.
Got it. Okay. Thank you very
Mr. Pro, stop. At that point, he really should have listened to his attorney. When your own lawyer is signaling you to be quiet, that's usually a strong hint to do exactly that. But instead, he couldn't resist squeezing in one last comment despite being clearly advised not to.
Mr. Deshane.
Thank you, Your Honor. I have a statement from the victim. She's observing on WebEx, but prefers to have me read the...
So they don't want to make an oral statement.
Correct.
Okay, that's fine. Thank you.
I'll be reading it in the first person as she wrote it, just to be clear for the court.
I got it.
Good afternoon, Your Honor. 30 seconds. That is all it took for Scott Probeck's anger and deliberate decision to change my life permanently. My husband and I were riding our bicycles home after a fun-filled day of listening to music and enjoying the evening when everything changed. I can still see Mr. Probeck's angry face as he yelled at us in the roundabout to get out of his way. After I exited the roundabout and entered the bike lane, Mr. Probeck turned his vehicle into the bike lane and struck me. I remember the moment of impact, being thrown onto the hood of his car and then hitting the pavement when he braked. That fear and violence are something I will carry with me for the rest of my life. The physical injuries from this incident are significant and ongoing. I suffered a fractured vertebra, a broken thumb, whiplash, and a compression injury to my arm. I also have permanent scarring on my calf from road rash. Healing is not meant returning to normal. It is meant adapting to pain, limitations, and the uncertainty of what long-term effects may remain. Beyond the physical damage, this incident shattered my sense of safety. I no longer ride with the same confidence or peace of mind. My husband and I both live with the emotional aftermath of that day. After reviewing the police footage and hearing witness statements, it is clear that Mr. Probeck acted out of anger and made a reckless decision that caused serious harm. This statement is intended to ensure that the court understands the full impact of those actions and the lasting consequences they've had on my life. I am deeply concerned about public safety, knowing that he will continue to drive despite intentionally using his vehicle as a weapon. I hope that the conditions of probation, anger management counseling, and bicycle safety education are enforced strictly to help prevent this from happening to someone else. This was not an accident. It was the result of rage behind the wheel, and it could have taken my life. I ask the court to consider the lasting physical and emotional and psychological harm this has caused and the ongoing risk to others who share the road. Warm regards, Tasha Qualls.
All right, babe. Thank you very much. I appreciate that. Anything else the microphone picks everything up, Mr. Probeck. So everything you just said, I'm sure Ms. Qualls heard it.
Only thing I would add, Your Honor, aside from asking the court to accept the stipulated plea of the parties, is as part of that, I do have a letter from Ms. Qualls' attorney assuring us that the insurance has taken care of the restitution.
Okay. That's okay. So what do you want me, in other words, no restitution? Is that what you're saying?
Correct. It's all been handled civilly.
Okay, got it. All right, Mr. Probeck, anything you wish to say before I impose a sentence?
And there, you have it, another fool landing himself in handcuffs for doing something reckless on the record. Maybe a short stay in jail will finally drive home the lesson that acting ridiculous in a courtroom comes with real consequences. All right, everyone, that wraps up today's video. We probably won't be seeing much more of that last guy, but the first two. I have a feeling they're not done making headlines just yet. If you enjoyed the video, hit the like button. If you didn't, that's fine too, leave a dislike. Either way, drop a comment below and subscribe with notifications turned on so you don't miss future uploads. I'm Team Skeptic, and I'm out.
Yes, sir. Obviously, only thing anyone wants to hear from me is to apologize to Ms. Qualls and her husband. Obviously, I feel horrible for the pain and injury I caused them. It was a nightmare for me too. It really was. I call it Nightmare in Remington. It felt like the events that happened. It was almost gothic. It almost felt like something out of a conspiracy theory or something. I was surprised to find this gentleman in the roundabout yelling at me and waving his hands. I didn't know what was going on. I was kind of in a bad place mentally. I was sad. I realized later I was withdrawing from this duloxetine, which was given to me to withdraw pain from diabetes. I have diabetic neuropathy. Didn't do that, but it's also it's antidepressant. So when you get off of it, it can cause you to feel overly sad, which I was feeling. It wasn't so much rage as an inability to control my impulses. What I did when I passed Mr. Qualls, he had the dirtiest look on his face, ugly look on his face, and I felt myself snap, like something came loose in me. And I entered another gear, and I saw myself with my hands on the wheel just go like that, just a little bit. And I was unable to resist that impulse because I was withdrawing from duloxetine. So I did that. I could have kept going, and Ms. Qualls was directing me to keep going, waving at me again. And instead of doing that, I did the opposite. And it was meant to be a quick little thing. I was just trying to scare her a little bit, just trying to be a little FU type thing. And it turned into the slow slide where it was just horrific. And to try to explain that was really hard at the time, because did you do it on purpose? Yeah, kind of, but I was out of my mind at the time. So, that's what it is. And I'm relieved that I didn't cause more damage to anyone. And I obviously intend to complete with this agreement and to prove myself being a good citizen in our community. And I hope that Mr. and Mrs. Qualls will accept my apology. And I wish the best for them. I tried at the time and obviously didn't go over very well. I mean, he just tried to punch me and got in my face and was hitting me. I could understand.
You're not helping yourself right now.
Okay.
So why don't you stop? Since you're
No
not-
sympathy from you, I guess, Your Honor.
I did ask you to stop. You're not the victim here.
Oh, I was in this too. My kids were on that beach too.
Mr.
Your
Probeck?
Honor. Stop.